Thank you, Mr. Chairman. Thank you, Dr. Woodcock. I'm looking at your draft, not for implementation, report on pharmacy compounding that was done in August of this year, and I want to clarify this court issue. Disagree with me and tell me yes or no. I'll ask you at the end of each part of this. But it appears that in April of 2002, based on this report, and I believe it to be correct, that the U.S. Supreme Court affirmed the Ninth Court's decision related to advertising and solicitation, but did not take up the severability as to whether or not the rest of the act would be in place after that date. Is that correct?
My understanding, yes.
And is it also correct that the Fifth Circuit found it was severable, and that decision was came out in 2008?
Correct.
The FDA took no action. Am I correct? The FDA took no action to clarify the law between 2002 and 2008 when the Fifth Circuit came out with their opinion. Isn't that correct? Yes or no?
Yes.
And it would also be correct that from 2008 until the incident with the fungal meningitis, the FDA never came to Congress and said we need clarification. Isn't that true? Yes or no?
Yes.
And isn't it true that you were working on these draft guidelines because you believed there was a way to figure out around the court decision issue and regulate to the best of your ability, with the Ninth Circuit being a little more difficult, but that's why you worked on these guidelines for over 3 years. Isn't that correct?
As I said, we were trying to make the best of a bad situation.
Wouldn't the right thing to have done to come for clarification on the severability and just reenact the old law and take the advertising section out? The only part that any court said actually violated the Constitution and the whole issue was severability. Wouldn't that have been the better thing to do from 2002 until 2012?
Yes, I think in retrospect that would have been better. I think there was a fear of getting a
Was there a fear of coming to Congress and asking for help when you needed it?
Well, you know, the late Senator Kennedy did develop a bill and ask around about it with some other senators, and there was so much opposition that they never introduced that. And I think
did the bill do anything other than clarify that the bill could be severed and that the only parts that weren't in place or should be in place were the advertising restrictions?
I'm not familiar with what exactly.
Okay, because I don't know what was in that bill, and I suspect there was something other than clarifying the law in there. And I would have to say in the draft guidance that you all were about to propose, the FDA described a new framework for compounded drugs that would be administered in a healthcare setting. And basically what you proposed was that you could compound for more than one patient in the hospital setting or in a medical practice setting, as long as there was a prescription that followed. If you knew you were going to use it like in an ophthalmological setting or in a hospital setting, as long as you could tie that later to a direct patient. Isn't that correct?
That's my understanding.
And so under that reading of that, other than clarifying that the advertising section is no longer the law, you really didn't need any new authority to do that, did you?
To make that
Yes
interpretation.
No? To make the interpretation.
I don't understand your question.
It's in your guidance request, so I assume that's correct. Is that correct?
That's correct.
Okay, and I appreciate that. And I'm looking up to see how much time I have left. We also have this business about talking to the states. There's nothing that prohibited you in the law from talking to the states when you got complaints from, say, Colorado or Ohio, which actually happened in the NECC case. Nothing prevented you from calling Massachusetts, did it?
No.
And in fact, in the guidelines, you're setting up a new way to make that work so that it's efficient. Isn't that correct?
The guidelines.
The guidelines of sharing information between the states and making sure that everybody's keeping an eye on
the guidance
these folks. The guidance, yes, ma'am.
Mm-hmm. Yes.
And so you didn't need any new authority to do that, did you?
We don't need new authority to talk to the states. We do that all the time in many different areas of regulation.
But you failed to do that in the NECC matter. And I guess my concern is that while I, too, have learned to respect your veracity and think you're a great witness, much better than that other lady that came in here. You know, we couldn't get anything straight out of her, so I do appreciate it. But I would have to say that, you know, one of my concerns is that the FDA had all these tools available to it if it had chosen to do so. And I understand people make mistakes, things happen. I understand that. I'm not being critical. But instead of asking for new authority, shouldn't we just clarify the fact that the advertising restrictions aren't the law, and that if there's areas that need to be clarified, not giving new authority, but just clarify some things, that we could follow your guidance proposal from August of last year and come up with a pretty good proposal. Isn't that true? Yes or no?
No, I don't think so.
So that was a bad proposal that you all were putting guidelines out on?
The guidance.
Yes or no? Were those guidance proposals bad?
They were based on the 503, which is not really that workable for the current industry that we have. I'm sorry, I can't give you just a no answer.
All right.
I
So
don't
if
think
you could
we have a
submit-
good.
I'm out of time, so if you could submit your recommendations, I would greatly appreciate it. Mr. Chairman, I yield back.
Chair thanks the gentleman, and now recognize the gentleman from Texas, Mr. Green, 5 minutes for questions.
Thank you, Mr. Chairman. Dr. Woodcock, thank you for being here today.